Hello everyone, this is Ray McGovern. Today, federal marshals began the process of seizing Trump properties to satisfy a $450 million civil fraud judgment. And what's happening right now is not symbolic. It's enforcement, real enforcement, the kind that involves asset freezes, property liens, and coordination between multiple federal agencies. And the documents that surfaced in the last 72 hours reveal something far more significant than most people understand. This isn't about politics. This isn't about opinion. This is about what happens when the largest civil fraud judgment in New York history moves from courtroom theory to actual collection. And the timeline, the internal communications, the asset inventories prepared by court-appointed monitors, all of it points to something that changes the entire conversation about accountability at the highest levels. Before we go further, subscribe right now because what you're about to hear is not being explained clearly anywhere else, and the details matter more than ever. Let me start with what triggered this. On January 9, 2026, the New York Attorney General's office filed an emergency motion for immediate enforcement. That motion cited 3 specific incidents of asset movement that occurred between December 20th and January 5th. I'm going to read directly from page 4 of that filing. Quote, "Respondent has engaged in systematic efforts to reposition high V-value assets beyond the reach of standard collection mechanisms, including the transfer of ownership stakes in multiple entities to newly formed limited liability companies registered in jurisdictions with favorable debtor protections." End quote. Read that again. Systematic efforts, multiple entities, favorable debtor protections. This wasn't a single transaction. This was a pattern, and it was documented in real time by forensic accountants who had been monitoring financial activity since the original judgment was entered. The AG's office attached 16 exhibits to that motion. Exhibit C is a wire transfer record showing $1 million moved from a Trump Organization account to a Cayman Islands holding company on December 23rd. Exhibit F is an email chain between 2 attorneys discussing the optimal timing for restructuring ownership of a Miami property to, quote, insulated from New York enforcement actions. The email is dated December 18th. The subject line reads, "Urgent prejudgment asset protection." One of the attorneys writes, "We need to move on this before the 15th. The 15th was the deadline for posting bond or securing a stay. They knew what was coming and they were preparing. But it gets worse. Exhibit J is a deposition transcript from January 6th. A corporate officer, whose name is partially redacted, was asked under oath whether any assets had been transferred out of entities named in the judgment. The officer answered number 3 days later. The AG's office produced bank records showing that answer was false. A commercial property in Westchester had been transferred to a Delaware LLC. On December 27th, the transfer wasn't disclosed. It wasn't reported to the court, and when confronted with the records, the officer's attorney requested an emergency recess. Now, the enforcement action that began this week is the direct result of those findings. On January 12th, a New York State Supreme Court judge signed an order authorizing the Attorney General to work with federal authorities to freeze assets and begin seizure proceedings. That order is 11 pages long, and it lists 23 specific properties and financial accounts. I'm not going to read all 23, but I'll give you a sample. 40 Wall Street in Manhattan, 7 Springs Estate in Westchester, a penthouse unit at Trump Tower, a golf course in Bedminster, a 51% stake in a Chicago commercial tower, a portfolio of securities held in a brokerage account under a corporate entity registered in Nevada. Each one is described in detail, legal descriptions, parcel numbers, account numbers, with the last 4 digits visible. This isn't theoretical. This is an itemized list prepared for enforcement. And here's the part no one expected. On January 13th, the U.S. Marshal Service issued an internal memo leaked to multiple outlets confirming they had been asked to assist with asset seizure under a provision that allows federal cooperation in state civil enforcement when fraud exceeds a certain threshold. That threshold is $100 million. This judgment is $450 million. The memo describes coordination with the IRS Criminal Investigation Division, which has expertise in tracing hidden assets, and with FINAN, the Financial Crimes Enforcement Network, which monitors suspicious financial activity. Think about that. The federal government is now involved in enforcing a state civil judgment because the scale and the alleged evasion tactics meet criteria that trigger federal jurisdiction. Let me read this word for word because it matters. This is from the Marshal Service memo, page 2. Asset seizure operations will commence on January 14th and will include physical inspection of properties, installation of court-ordered locks and signage, and coordination with local law enforcement to ensure security. Occupants will be notified of judicial authority and given lawful instructions. Resistance will be documented and reported to the issuing court. That was written on January 12th. This was planned. This was coordinated, and it started exactly when they said it would. Now, what does physical seizure actually look like? Because there's confusion about this, and it's important to be precise. Seizure doesn't mean bulldozers and evictions on day one. It means the property is legally frozen. It means ownership is effectively transferred to the court's control. It means no one can sell it, mortgage it, lease it, or move it without judicial approval. In the case of real estate, marshals arrive, they post notice, they change locks if necessary, and they inventory contents. In the case of financial accounts, the accounts are frozen and any attempt to move money is blocked. In the case of business interests, a receiver can be appointed to take over management and ensure the asset generates revenue that goes towards satisfying the judgment. And here's where it gets even more specific. On January 14th, marshals were photographed outside 40 Wall Street. The building is a 40-story office tower in Lower Manhattan. It's been valued at over $200 million. The photos show two marshals entering the building at 9:43 a.m. They were inside for 2 hours. When they left, a notice was posted on the front entrance. That notice, which was photographed up close, states that the property is under judicial seizure pursuant to a New York Supreme Court order, and that any interference with the seizure is a contempt of court. The notice includes a case number, a judge's name, and a contact number for the clerk's office. It's official, it's public, and it's enforceable. Now, the Trump Organization released a statement on January 14th, calling the seizure illegal and politically motivated. The statement said they would appeal and that they were confident the judgment would be overturned. But here's the problem with that statement. The judgment was entered 4 months ago. There have been 2 appeals already. Both were denied. The bond requirement was set at $450 million plus interest, which brought the total to over $470 million. That bond was never posted. A stay was requested and denied. Every legal avenue to delay enforcement has been exhausted. So when the statement calls it illegal, that's not a legal argument. That's a public relations strategy, and the documents make that clear. On January 10th, Trump's legal team filed a motion for an emergency stay pending a new appeal. That motion argued that seizure would cause irreparable harm to business operations, and that the judgment amount was excessive. The Attorney General's office filed a response the same day. I'm going to read one paragraph from that response because it's direct. Quote, "Respondent has had months to post bond, secure alternative financing, or negotiate a payment plan. Instead, respondent chose to transfer assets, obscure ownership, and ignore court orders. The harm respondent now claims is entirely self-inflicted and does not justify further delay in enforcing a lawful judgment." End quote. The motion for a stay was denied within 18 hours. The judge wrote a 1S sentence order. Motion denied for reasons stated in the Attorney General's opposition. Now, let's talk about the other properties because 40 Wall Street is just one of 23. On January 15th, marshals were seen at 7 Springs Estate in Westchester. That's a 213-acre property that was at the center of some of the fraud allegations in the original case. It was allegedly overvalued by more than $100 million in financial statements submitted to lenders. The property is not currently occupied, but it's maintained by a staff, and there are security systems in place. Marshals conducted a full inventory. That inventory has not been made public, but sources familiar with the process say it includes artwork, furniture, vehicles, and a wine collection stored on site. All of it is now under court control. The golf course in Bedminster is more complicated because it's an operating business. It has members, employees, events scheduled. Seizing an operating business doesn't mean shutting it down. It means appointing a receiver to manage it, and that's exactly what happened. On January 14th, the court appointed a financial management firm to take over day-to-day operations. The firm specializes in receiverships for high V-value estates and businesses in litigation. Their job is to keep the business running, generate revenue, and ensure that revenue goes toward the judgment. Employees still get paid, members can still use the facilities, but the profits no longer go to the Trump Organization. They go into a court-controlled account. And here's something most people don't realize. The judgment isn't just $450 million in cash. It includes a ban on doing business in New York for a period of 3 years. It includes a ban on serving as an officer or director of any New York corporation. And it includes the appointment of an independent monitor to oversee financial reporting for any remaining business operations. That monitor has been in place since November, and the reports filed by that monitor are part of what triggered the emergency enforcement motion. The monitor found discrepancies. The monitor found asset transfers. The monitor found non-compliance. And the monitor reported all of it to the court. Now here's where it connects to something bigger. This judgment stems from a case that began in 2019. It involved allegations that financial statements were inflated to obtain loans and deflated to reduce taxes. The case was tried without a jury, which means the judge made all findings of fact. The judge found fraud, not once, not twice, repeatedly. The judge found that property values were misrepresented by hundreds of millions of dollars. The judge found that those misrepresentations were intentional and that they were used to gain financial benefits, and the judge imposed a penalty designed to remove those benefits and deter future misconduct. The appeal process has been ongoing, but every court that has reviewed the case has upheld the core findings. The appellate division affirmed. The motion to reduce the judgment was denied. The motion to delay enforcement was denied. And now enforcement is happening not because of politics, not because of bias, because the legal process reached its conclusion, and the conclusion requires payment. But let's talk about what happens if the assets seized aren't enough to cover the judgment, because that's a real possibility. The AG's office has said publicly that they will pursue every available asset until the judgment is satisfied. That includes assets held in other states, assets held through shell companies, and assets held in trusts or family entities. There are legal tools for doing that. One is called a charging order, which allows a creditor to claim distributions from an LLC or partnership. Another is called a fraudulent conveyance action, which allows a court to unwind asset transfers that were made to avoid paying a judgment. And the AG's office has already filed preliminary motions indicating they intend to use both. On January 11th, they filed a motion to compel discovery of all financial interest held by Trump or entities he controls. That motion asks for bank statements, corporate records, trust documents, and tax returns going back 5 years. The motion argues that respondent has not provided a complete accounting of assets and that such an accounting is necessary to ensure full enforcement. The judge granted that motion on January 13th. Discovery is now underway. And here's what that means. Forensic accountants are going through every financial record they can access. They're looking for hidden accounts, offshore holdings, nominee owners, straw transactions, anything that suggests assets were moved to avoid enforcement. And they're doing it with subpoena power, which means banks, brokers, attorneys, and accountants have to comply. Failure to comply is contempt of court. Now, let's pause and think about what this reveals. This is not a criminal case. No one is going to jail over this. But the consequences are severe. Properties are being seized. Businesses are being taken over. Financial privacy is being stripped away. And all of it is happening through a civil process that was designed to address fraud in business dealings. The standard of proof in a civil case is preponderance of the evidence, which means more likely than not. The judge found that standard was met. The appellate courts agreed, and now the system is doing what it's designed to do, enforce the judgment. But here's the broader question. If this were anyone else, would we be surprised? If this were a CEO of a mid-sized company who was found to have inflated asset values by hundreds of millions of dollars to get loans and then refused to pay a court-ordered penalty, would we expect enforcement? Of course we would. We'd expect the properties to be seized. We'd expect the accounts to be frozen. We'd expect the legal system to follow through. So why is this different? The only difference is the name. The only difference is the profile. But the law doesn't change based on who you are. The process doesn't stop because you're famous or because you held public office. And that's what makes this moment significant. Because for years, there's been a question about whether accountability applies equally. There's been a question about whether people in positions of power can use delay, appeals, and legal maneuvering to avoid consequences indefinitely. And what's happening right now is an answer. The answer is no. The courts have limits on patience. The system has mechanisms for enforcement, and when those mechanisms are triggered, they work. Now, let's talk about the politics of this because it's unavoidable. There are people who will say this is a witch hunt. There are people who will say this is partisan. There are people who will say the judgment is unfair and the enforcement is overreach, and those people are entitled to their opinions. But opinions don't change facts. The facts are in the court record. The findings were made by a judge after a trial. The appeals were heard and denied. The enforcement is lawful. You can disagree with the law. You can disagree with the judgment. But you can't claim it's illegitimate just because you don't like the outcome. And here's why that distinction matters. Because if we accept the argument that enforcement is illegitimate whenever it involves someone we support, then we're saying the law is optional. We're saying that court orders only matter if we agree with them. And that's not how a legal system works. That's not how a society works. Courts have authority, judges issue orders. Those orders are binding. And if you don't comply, there are consequences. That's not tyranny. That's the rule of law. Now let's talk about what happens next, because the seizure process is just beginning. It will take months, maybe longer, to liquidate assets and collect the full judgment amount. Properties have to be appraised, marketed, and sold. Businesses have to be managed and eventually transferred or dissolved. Financial accounts have to be audited and distributed. All of that takes time. But the process is in motion and it's being supervised by a court, which means there's transparency, there will be hearings, there will be reports, there will be public records, and anyone who wants to can follow what's happening. And that's important because this isn't happening in secret. This is happening in open court under judicial supervision with legal representation on all sides. It's adversarial, it's procedural, and it's documented. So when people say this is unfair, ask them to point to the specific ruling they disagree with. Ask them to explain which finding of fact was wrong. Ask them to show why the appellate courts got it wrong, because if they can't do that, then they're not objecting to the process. They're objecting to the result, and that's not the same thing. Now, there's one more piece of this that needs to be said. The original fraud case was about misrepresentation in financial statements. It was about telling lenders that properties were worth more than they were. It was about telling tax authorities that properties were worth less than they were. And the reason that's illegal is because it distorts markets. It gives an unfair advantage. It shifts risk onto others. Banks make lending decisions based on asset values. Investors make decisions based on financial statements. If those statements are false, the decisions are misinformed and the risk is misallocated. That's why fraud laws exist. Not to punish opinion, not to punish optimism, but to punish intentional misrepresentation that harms others. And the court found that misrepresentation happened not once, not in a single instance, but repeatedly over years across multiple properties and financial statements. The court found that the misrepresentations were significant, sometimes by hundreds of millions of dollars, and the court found that they were intentional. That's fraud. That's what the judgment is based on, and that's what's being enforced. So when you hear that properties are being seized, understand what that means. It means a court determined that fraud occurred, that financial gain resulted from that fraud, and that a penalty is owed. It means the legal process ran its course, and enforcement is the final step. It means the system worked the way it's supposed to work. Now, I'm not making accusations. I'm reading what's in the file, I'm describing what courts have found, I'm explaining what enforcement looks like, and I'm asking the same question you should be asking. Does the law apply to everyone, or doesn't it? Because if it does, then this is what accountability looks like. If it doesn't, then we need to be honest about that. And we need to have a very different conversation about what kind of system we actually have. This isn't about one person. This is about a principle. This is about whether a court judgment means something. This is about whether you can commit fraud, get caught, lose in court, lose on appeal, and still walk away. And the answer, at least right now, is no, you can't. The properties are being seized, the accounts are being frozen, the enforcement is real, and it's happening because that's what the law requires. Thanks for watching. Subscribe, share this, and stay alert. Don't let anyone tell you this doesn't matter, because it